Hi everyone, this is Sahil Malhotra, an intellectual property attorney at Drashi Law. Today I will talk to you about geographically descriptive refusals. If you're on this page, you've probably received a provisional refusal from the USPTO, or you're really interested in trademark law. An applicant without a trademark attorney is more likely to receive an office action than when an applicant files with a trademark attorney. Most trademark applications have to deal with provisional refusals that can be overcome with an effective office action response. An effective office action response requires a thorough understanding of trademark law and the ability to craft favorable arguments specific to the facts of your application. What is a geographically descriptive refusal? The United States Patent and Trademark Office, USPTO for short, will apply a 2E2 geographically descriptive refusal to all marks where the primary significance of the mark is that of a publicly known geographical location. The goods and or services originate from the publicly known geographical location, and the consumers would associate the goods and or services with the geographical location. For example, Lexington, for a bourbon whiskey distilled in Lexington, Kentucky, is geographically descriptive. This policy aims to avoid monopolizing a common word that other brand owners may use to describe their goods and services. How to overcome a geographically descriptive refusal? As always, the trademark application process is subjective, fact-dependent, and comes with no guarantees. To overcome a geographically descriptive refusal, an applicant can argue that the primary significance is not the geographical location mentioned in the applied for mark. So in our example, we would have to argue that Lexington is not the primary significance of the applied for mark, or the location mentioned is obscure and not well known to the public. The geographical location mentioned in the mark would have to be so obscure or remote that an average American consumer would not be able to associate it with the goods and services offered under the applied for mark. Or the mark has acquired distinctiveness and can prove it through evidence. Acquired distinctiveness can be shown through advertising or promotional materials, funds spent on the promotional materials, market participants, which is consumers and dealers, statements indicating the recognition of the applied for mark as a trademark, or any other evidence showing the consumer's recognition of the applied for mark as a trademark. Please comment below if you have any other USPTO refusals that you'd like me to discuss. I hope I've shed some light on what a geographically descriptive refusal means for your application. Common refusals like these are avoidable by consulting a trademark attorney and conducting a preliminary search and clearance for your mark. If you have questions regarding your trademark application process, please click the link below to book a call. As always, this is Sahil Malhotra. Thank you for watching.